being generous with your time and speaking to CPR today. We really appreciate it. So I'm just going to start and ask you a question about sort of how you got to where you are now. You've been an arbitrator for many decades. Can you take us on a short tour of your legal career and how you came into the world of arbitration?
I was asked that question the other day, whether I found arbitration or arbitration found me. And I think it's a combination of both, in that I recognized an opportunity and I seized upon it. But I left this US to travel for a year in Europe. I had done, among many things, security studies at the Fletcher School, and I was fascinated by the geopolitics of world events. And so I ended up in Spain, where I had some friends from my class at the Fletcher School, and I decided, I'll hang out there for a while. And I thought, while I'm hanging out, I should do something useful. And I got this job as a translator with what is and continues to be one of the prominent arbitration practices in Spain. And I saw an opportunity there because at the time, Spain had just joined the European community, it was at the time, and had just joined NATO. And a lot of foreign direct investment was coming into Spain because of their competitiveness, among other things, prices, labor costs, the likes. And it was a good place from which to, provide a platform for operating in Europe, but importantly, a platform for operating in Latin America. And I started to translate, I started to see transactions. I started to be useful to common law lawyers coming into Spain and into the civil law jurisdiction, and helping them understand the nuances of concepts and practicing in a civil law country. And one thing led to another. I became admitted to Spain as a lawyer, and decided to stay. Decided that there were more opportunities for me there than there were in the States in terms of developing a career in arbitration. I started out as a transactions lawyer, became counsel to parties in arbitrations, and started to receive appointments. I owe all this, I think, to Bernardo Cremades, who was a mentor for me. He provided the opportunities. He allowed me to be at the moments of international arbitration, concepts like competence, and all the things we take for granted now. Excuse me, back in those days were not accepted concepts. There was a lot of pushback with respect to these concepts. And I was there as they tried to find solutions to problems. And part of the solutions were these concepts like competence, separability, and all these different things. And I was there, and through Bernardo and his auspices, I was able to see these concepts develop. I joined his firm as a lawyer after being admitted, and ran transactions, cross-border transactions, as I said, which led to negotiating arbitration clauses. Among the many clauses we negotiated, being in a practice that was very heavily arbitration related, I was able to call on very good expertise with respect to negotiating these clauses. As I said, my clients started to ask me to represent them in arbitrations as counsel. And then I started to receive appointments from institutions. And I think that's what it is. So I have a common law background and I have a civil law background. And I think that was attractive to many of the users and practitioners in arbitration.
Great, thank you. So sounds like a combination of having the right skill set, being at the right place at the right time, and having an excellent mentor, and all of those factors combining to sort of push you forward.
That's right. And last but not least, understanding the culture, speaking the language, but not only speaking the language, understanding who is a Spaniard, who is a European at a time when Europe was coming together. And I think, and I throw this back now to the Fletcher School experience, because a lot of the things we were taught in theory began to come together there in practice. And so I remember fondly those 2 years I spent at Fletcher, and I give them a plug. I did the Master's at Law and Diplomacy degree, and I think that helped me a lot to understand my moment.
That's so interesting. So having a sort of sense or understanding of the international political economic context helped you sort of capitalize on the moment.
Yes, yes, yes.
Interesting.
Absolutely.
So I understand that you've been very active promoting arbitration both in Spain and throughout the Caribbean and Latin America. Can you talk a little bit about those activities?
Yeah, I had been, as I said, fortunate to be part of an institution that grew in Spain. We were part of introducing the new model law in 1988 in Spain. We were part of the process in introducing the new law in 2003. And I got to see essentially what went into providing a platform for international arbitration to work in a particular jurisdiction. Among the institutions I was involved with was the Club Español de Arbitraje in Spain, which was developed essentially to promote arbitration, to help with the transition from the 1953 law to the 1988 law, and then the model law in 2003. And the Club Español de Arbitraje had the vision to understand that we could also help, based on our experiences, based on our language, based on our skills, the transition in Latin America, which was a jurisdiction, well, the continent of South America and then Central America, the common language, some of the common cultural past. And I say that carefully because not all of the history between Spain and Latin America, Central America is still not well received. But in the instance of the arbitration, the Club Español de Arbitraje played a very important role in assisting, understanding, and appreciation for this alternative dispute resolution mechanism in Latin America. In the advent of the Pan American Convention, which did for arbitration in Latin America what the convention, the
New York Convention,
the New York Convention, thank you, for international arbitration. The Panama Convention was instrumental in that because it sort of lowered that barrier, that concern, that reticence for foreign direct investment and what it meant, the negative influence of foreign direct in Latin America. And so the Panama Convention did that. And then we came along, the Club Español de Arbitraje, and we were able to build on that and to begin in their language, understanding the nuances of the language as we translated and explained these concepts of international arbitration. That was very well received, and it broke down a lot of the barriers that existed in Latin America. So I was a part of that. I came to the Caribbean in the 2014. I was born in Guyana, incidentally, which is not geographically in the Caribbean Sea, but because of politically and economic and cultural and social reasons. And the colonial past, we're part of the Caribbean. And so I came back to the Caribbean in 2014, essentially to try to get them over those hurdles that we had just done in Latin America. And so I'm quite active in trying to prepare the legal platform framework for which arbitration can flourish here in the region through university classes, through training, conferences, helping them most importantly with legislation, modern legislation based on the model law. We have developed a draft arbitration bill, which is, excuse me, referred to as the Impact Justice Draft Model Arbitration Law. And that has been well received. A number of jurisdictions are now considered model law jurisdictions: Barbados, Jamaica, the BVI, and Guyana and Trinidad now are looking to implement the model law. So we've been quite active in doing that.
And it sounds as if these efforts are really bearing fruit, that arbitration is really starting to gain traction and legs and usage.
Yes, yes. There was a reluctance, and that same reluctance we saw in Spain. We saw it in Latin America, maybe for slightly different reasons in Latin America. But we see them here. You know, people are comfortable doing what they know to do. You know, if it ain't broke, don't fix it kind of
Right, right.
And so, they're happy with litigation. Why introduce this thing which they might not be fully versed in pursuing and doing it. In fact, my interest in coming back to the Caribbean arose because of sitting as an arbitrator in four different cases over a period of about 4 or 5 years or so. I noted the lack of command, dominion, and control of the process. They were good advocates, very good advocates, but the process was delayed. They treated it as if it were litigation in the court and the likes. And so I noted that, and I had some conversations, started to come back to speak in the region, and realized that I needed to be here more often than just doing it from Spain and the likes, and hence the decision to be here more permanently. But yes, it's taken hold. People are now excited about arbitration. Some of them kicking and screaming to the table because of we are foreign direct investment recipients. So the investments come with conditions, including arbitration as a dispute resolution mechanism. The international lending agencies provide now for dispute boards with respect to the projects that are being developed. So all these things now have come together to make the different jurisdictions in the region aware of the fact that they need to get on board this train. It has already left the station, so they need to do it as a matter of urgency. And that urgency has come together. We've now arbitration institutions in the BVI. We've arbitration institutions in Jamaica, institutions in Trinidad, in Barbados. And they're all working, albeit slowly, many of them. The BVI, I would suggest, is ahead of the curve. They've set up a magnificent facility and institution. They've got the infrastructure. And importantly, they have had the financial funding to do this. It's important that the regimes, the governments get behind these initiatives. If you look around the arbitration community, all the jurisdictions that have prominent arbitration institutions, it's no secret that they're all begun with either financial support and or political support behind these institutions. In the States, it is novel, shall I say, that the private sector is a proponent and player, major player in all of these initiatives. And as a result of that, the funding and the participation and the likes come. But I think the US is sort of a...
Maybe an outlier?
Well, and I think the US does an excellent job. They used to be a naysayer, laggard with respect to arbitration. It's no longer the case, but they used to be back in the times. But I think for the rest of the world, the governments and the financial support from governments played an instrumental role in the development of arbitration and institutions in those particular jurisdictions: Singapore, Kuala Lumpur, Hong Kong, all these places.
I note that you also have taught in various academic institutions. Is that all part of this push to kind of enhance competency, both in terms of creating a platform, but also the competency of the various actors, the various attorneys who would be?
Yeah, naturally. Like everything else, the reluctance to participate in arbitration, it was essentially education. They just didn't know the process. They needed to know the process. They needed to understand, why it's important, how it fits in to the whole interdependent world economic development schemes, and how to provide wind at the sails to be able to continue with investment and projects and have people to participate in them. And where do you do that? Well, you do it at the institutions. When I went to school, there were no arbitration courses. When I went to Fletcher, there was one arbitration course taught by one of my favorite professors, William Barnes. And it was my first contact with the whole concept of arbitration. And so that's changing. And so I think, my role as lecturer, professor, helped to do that. You get the students excited about it. When they go out now into the world, they may not land at the prominent law firms where arbitration is flourishing and alive and well. They may land at a small firm that is the general practice sort of firm. But if and when that rare case comes in and the senior partner says, there's this thing called arbitration, how do we do this? And you say, well, I had, Calvin Hamilton's course. And so I know, yeah, you have an arbitration clause. Let me look, and there it started. Guess what? You may get to be on that case, that kind of stuff. So it's important to treat it well, like everything else. You educate the potential users, and that is it. So I think it's very important to start at the ground level, the grassroots level, and build out.
I want to talk for a minute about your role as an arbitrator. Are there any particular cases that stand out to you as having been particularly challenging, and what you see as the strengths that you bring into the process, apart from an obvious encyclopedic knowledge of the process and all of your experience?
There have been quite a few cases that stand out for different reasons. There's one case right now that I'm sitting. It's one of these arbitrations under the old Arbitration Act in Barbados, which provides for 2 arbitrators and a potential and for an umpire. It doesn't provide for a 3-member tribunal. And fortunately, the co-arbitrator was amenable to an umpire that completed diversity, but in this case, regional diversity. Another thing is, as a tribunal, although it was just 2 arbitrators and an umpire, in the context of the training that young people need in arbitration, we agreed with the parties to appoint a secretary to the tribunal. And we looked for someone who was versed in arbitration, and had some experience, but needed to build on that experience. And this was a wonderful opportunity for that person to be able to do that. And so, in consideration of the parties' concern for additional costs, we were mindful of that concern. And so we indicated to the parties that whereas we would normally be developing the proceedings in areas which could be sort of repetitive and mundane and the likes, at a rate that's not cheap, if the secretary could be performing those tasks at a reduced rate, the benefit, they derive the benefit. And that was a convincing argument for them. They said, well, yeah, fine, just so long as you instruct and you control whatever the secretary is doing and the likes, which is to be expected. We were able to do that. So for me, that was one of those opportunities to do something, put your money where your mouth is with respect to the process, in consultation with the parties, with the approval of the parties' approval of that. So that I think was an important case in that context. There one particular case that immediately comes to mind also was a case where I was able to change the rules of an arbitration institution to include consolidation before we gotten into the whole. Most of the institutions now have consolidation of proceedings and cases and the likes and parties. This particular institution didn't have those rules. And so there were 4 arbitrations, same parties, same contracts, same arbitration clause, but they were brought as 4 different proceedings, matters. And I didn't have the power to consolidate. I needed the parties' permission, which I didn't receive. The party, they didn't get along, and so it was difficult for them to do anything. And so I had to run concurrent arbitrations with that. The problem with that was that I had 4 separate awards which I knew were going to be challenged because of one of the parties' recalcitrant behavior and the likes. And so I knew that was the case. And it raised the question of who do you write the award for? Well, in this case, not only the parties, but I was writing for the courts. But my concern was that this was in Spain. What we call the reparto, the distribution of the cases at the courts that would receive arbitration related litigation, each case would go to a different judge. There was no guarantee that the same judge would get the 4 cases. So you run the risk of 4 separate and maybe contradictory decisions for essentially the same sets of circumstances. Fortunately, 4 cases came down that there was no basis for setting aside the award. But that, and then immediately after the institution changed the rules to allow the power of the tribunal to consolidate.
Yeah.
And so that was a good case with respect to a particular public outcome.
Yeah.
We talk about, corruption in arbitration. I think one of the previous surveys you had sent to me, I think, included this question. And there was one case where I suspected there was corruption. There was a money laundering operation going on. And so the question was raised, when, if at all, can the tribunal investigate sua sponte corruption in the proceedings where the parties didn't raise the issue? And I believe then, I still believe now, that where the issue of corruption influences the enforceability of the award, even though the parties may not have raised the issue, I think the power and the capacity of the tribunal to investigate, I think, is there. And this interpretation is from the rules. We have to effectively, efficiently produce an award that's enforceable. And in that context, I believe I was correct in pursuing this, asking for documents to satisfy my own concerns that there was not a corrupt scheme going on. What had happened is that the parties that come to me and asked me soon after the arbitration begun, shortly thereafter, that they had reached an agreement and they wanted me to provide an award by consent. And I suspected that there was something going on. It turns out that there was. It turns out that when I started to ask the documents, none were forthcoming. And so this was an ICC arbitration, so I had to convince the court that indeed my refusal to provide the consent, which was my discretion under the rules, was based on what I suspected to have been. And I explained to them, I wasn't on the court then, I'm on the court now, and I now understand the process, why they asked for it, and the discussion that went into at the court level, this particular matter, because the court had to pronounce on, among other things, questions of fees and all different things. And of course, the court doesn't want to be the mechanism for allowing parties to conduct fraudulent, corrupt activities and the likes. And so now I understand better the court's questioning to me and the opinion that they wanted me to produce for the court, why they did that. And then indeed, they accepted my opinion, they accepted what I said. And so that particular activity did not bear fruit.
So I'm noting a theme here that these cases that kind of come to mind have significant public policy implications, whether it's generating new rules for consolidation or ensuring that the process isn't tainted by the corrupt activities of the parties, or even working to help mentor younger practitioners so that they can progress in their career and get experience, which is not always so easy for younger practitioners. I want to close our discussion with a last question on diversity, which remains another public policy question that we continue to work on and wonder what the best routes forward are. Where do you think we stand on the question of diversity in alternative dispute resolution?
We could do more. We could do more. And I understand the complexity of it. The autonomy of the parties to determine who they select as arbitrators, who they appoint as lawyers, I think is to be respected, is paramount. But is that the end all? Are there times when the autonomy could be influenced by a greater good, I think. And I'm careful here because, again, I sit on the court and I see what we do at the ICC. And we're doing wonderful work at the ICC. The other institutions are doing excellent work also in this area. But I believe while gender diversity is significant, and while there should have been and continues to be emphasis on gender diversity, I believe similar pressures, similar interests, effort, energy should be paid to the other aspects of diversity. And I don't think they're not being developed with the same energy as gender. And again, please, I don't want to be misunderstood here. I am not saying that we should claw back what we've done in gender diversity. I'm saying that we continue to do that and we continue to do more, absolutely. I believe also that the other areas, ethnicity, regional, cultural, linguistic, all these other aspects of diversity should also receive similar energy. And I don't know that they are. Now, I recall a number of years ago, Jan Paulsen had said that, among the many comments, positions that he had taken, he tried to defend the position that institutions should appoint the arbitrators. And there was a lot of pushback for that, and including myself. But if there is an institution in arbitration, institution being defined as the players and the stakeholders, that can do this better than anybody else, parties, clients, it's the institutions, I think, because they get to see the process. They get to see the dispute. They get to determine, and they do a very good job of defining the needs and the profiles of the arbitrators. So maybe, just maybe, if we take a step back and we revisit the Paulsen suggestion in the context of the diversity. I know you can't isolate it. I realize that. That's why I said it's complex. But I think the institutions can do a much better job than the parties do. The parties, of course, obeying their zealous need to defend their interests. And I get it. But many times that definition of zealousness overlooks or doesn't give additional priority. And I use the word additional deliberately because many things go into selecting your arbitrator, but they should also include diversity when you pick that professional. And if you tell me that you cannot find a professional that ticks the arbitration diversity box while at the same time ticking the professional accomplishments box, you haven't looked far enough. And there are a number of lists. There are people out there that can do an excellent job for you. I'm sitting with two of them right now that are fascinating. with their knowledge and command of the arbitration process and the subject matter. And we have these discussions about how often you're appointed, what are you doing, anything. And it's unfortunately not often enough when you compare other appointments. And I do believe that while, and again, I emphasize, it's no longer taboo to talk about diversity. For some people, it's still uncomfortable. And I get that too. I get that too. But we have to talk about it. And, you know, the Jay-Z case, I don't know if you recall.
Yes, of course.
You know, whether or not we can get into what strategic interests Jay-Z had for raising the exceptions that he did raise. The point of the matter still is he did not see on that list people that looked like him. And that's a fact. That continues to happen. And I think we are better than that. I think there was a list that was prepared, I think in 2020 or so, by two of the prominent US arbitrators and arbitrators of African descent. And you know, you can go to that list, and I've heard the comment that it's not user-friendly, and I agree with that. It's one of the suggestions I made to the people that created the list, that they need to make it more user-friendly. But if they were to do that, but even if they didn't do that, you know, if you really are interested in finding an arbitrator with the qualifications to suit a particular transaction, you can find that arbitrator right there. If indeed all the other things being equal, expertise, all the different things, you can find an arbitrator right there. I'm a product of affirmative action. And I got my first job from affirmative action. Now that's a good concept that went bad because people didn't care enough for it. I think people deliberately undermined the process, but it was a very good idea. And the idea was simply, all things being equal, give a nod to diversity, but not give a nod to diversity at the expense of expertise and ability. That's not to be done. And so while we've done quite a bit, there's more to be done, and I'd like to see us do more. I'd like to see parties do more. I'd like to see in-house counsel be more involved in who the arbitrators or their counsel are. I'd like to see outside counsel actively promote diversity. I don't know that they do that with the fervor that it should be done. And I believe that regional institutions, clients, businesses also should include in their list diversity. Now, it is not sufficient to include in your list somebody who ticks the box, knowing full well that the party still will not select that person. But you've just done it just to tick a box. That's not good enough either. And that is being done. So I don't know if I responded to your question. It was a long way around, but I do believe that we are making progress. I think we can do a bit more.
Well, I know that CPR is very interested in moving the needle forward. So we're very interested in the ideas of people like you who have been steeped in arbitration and have lots of experience and ideas of how to move forward. So I want to thank you for speaking with us, speaking with me, and look forward to our next opportunity to chat together.
Absolutely. Thank you very much, Ellen. It's a pleasure to be here with you. And however I can help, just call me.
We will. Thank you so much.
Thank you. Bye now.